Begin transmission. Greetings citizens of the Sunshine State. Today's date is Monday, October the 23rd, 2023. We are anonymous, also known as the Collective. This message is for the Governor of Florida, Ron DeSantis, the Florida Inspector General's Office, State Attorney Office for the 4th Judicial Circuit, the Florida Bar Association, the Florida Judicial Qualifications Commission, and Transparency International. First, we would like to state the information shown was provided by the person in these court documents. His name has not been redacted, per his request, but during this video he will be referred to as the respondent. Judicial misconduct envelops a broad spectrum of examples. However, the example given here depicts the actions of the court in this given situation. The judge ignores certain laws or precedents. This is uncommon because a judge typically cannot ignore a law without explaining. December 17, 2018, an attorney, Renita Henry, decided to omit critical information while representing her client in a Title 4D case in the 11th Judicial Circuit Court of Florida. The omitting of 3 core elements represented a breach of Florida Statute 61.30. Compliance being the theme here, Ms. Henry refused, and chose to withdraw on January 8, 2019. On January 28, 2019, General Magistrate Deborah Nabat Frankel would adjudicate a recommended order while possessing knowledge of the omissions. This means the magistrate was made aware Ms. Henry's misconduct. A final hearing on April 29, 2019, took place. Judge Scott Bernstein would uphold the recommendation of General Magistrate Deborah Nabat Frankel, while informing the respondent to file an appeal of his verdict. A lawsuit was filed again, and on August 6, 2020, Judge David C. Miller dismissed the case, just minutes before recusing himself. On May 4, 2023, at a hearing to enforce the April 29, 2019 court order, General Magistrate Gina Menzlock disregarded the applicant's motion to vacate the order based on fraud on the court. The General Magistrate insisted that the motion was not on the docket. The General Magistrate chose to enforce the 2019 court order while possessing knowledge that an exhibit which was submitted by the other party's attorney was in breach of Florida Statute 839.13. This violation occurred due to the exclusion of information on a document, which would render the court incapable of adjudicating an impartial verdict. On May 11, 2023, Judge Samantha Ruiz Cohen, while acting under color of law, chose to support the recommendation of General Magistrate Gina Menzlock. Handed down the biased decision, the respondent filed a motion to recuse Judge Samantha Ruiz Cohen and a motion for change of venue. Both motions were denied. Looking at this case with an unbiased set of eyes, it would appear the 11th Judicial Circuit Court of Florida does not care about justice, especially when it's time for the rendering of justice to one of their own. It also seems that no confidence can be considered regarding the leadership if Chief Judge Nushin G. Safi. If an attorney knowingly misrepresents information to the courts, does that not constitute fraud? We were under the assumptions that attorneys were officers of the courts. If the court's officers circumvent and defraud the courts, then regular citizens should be given the same considerations. Admissions of guilt in the eyes of the law still constitutes guilt. Recently in Florida, a number of attorneys and judges were given a taste of justice when Governor DeSantis stepped up to the plate and stepped into administering justice to those who think they are above the laws. We will go through the following exhibits just in case the Florida judicial system is interested in doing their jobs. Exhibit A, email correspondence between attorney Renita Henry and opposing counsel Emily Phillips. In this exchange, Ms. Henry confessed to the deliberate omission of Delaware state tax, Wilmington city tax, and mandatory retirement salary deductions while computing child support responsibilities. As illustrated in Exhibit E, these actions by the respondent's former attorney constitute a violation of Florida Statute 61.30. Exhibit B and C, consist of duplicates of the child support worksheet, each meticulously filled out by Attorney Renita Henry and General Magistrate Deborah Nabat Frankel, respectively. Exhibit D is a copy of an email exchange between the respondent and opposing counsel Emily Phillips, where he reiterated the exclusion of critical information from the case. Exhibit G is a copy of the respondent's financial affidavit. Exhibit I comprises a reproduction of an email sent by the respondent's previous attorney, Renita Henry, wherein she requested the respondent to relinquish his rights. This request was made after she misrepresented a crucial material fact by omitting salary deductions. These deductions were later inaccurately reflected as net income in her calculations. The respondent insisted that she correct the omissions. Instead of correcting, she hastily withdrew from the case. Ironically, another child support worksheet was calculated by opposing counsel Emily Phillips to indicate that the child support should have been even greater, which surprisingly represents a gross disregard for the tenets of Florida statute. Exhibit N and P represent a court order that signifies the dismissal of the respondent's legal action against his former attorney. This dismissal pertained to her intentional misrepresentation of the respondent's information to the court. Notably, Judge David C. Miller recused himself within minutes after delivering his verdict. This is a response from the Miami-Dade State Attorney's Office. In their decision, they asserted that Attorney Renita Henry had not deliberately falsified or concealed any facts, despite her clear admission to the act. This is a court order from the 3rd District Court of Appeal, where a dismissal of the appeal against the respondent's former attorney, Renita Henry, was upheld. Their decision stemmed from their assessment that no fraudulent activity had been committed. Isn't it funny that statements by a prosecutor in court constitutes facts, but the possession of admission of guilt in writing by the respondent is dismissed? Most recently, Judge Samantha Ruiz Cohen of the 11th Judicial Circuit Court of Florida, as documented in the respondent's recent TikTok video, which can be found here at voicearrest.53. In a startling turn of events, Judge Cohen was permitted to preside over the case despite being named as a defendant in the respondent's federal lawsuit against 4 judges, 2 general magistrates, and 2 attorneys in the Southern District Court of Florida. It's noteworthy that in that particular lawsuit, Judge Cecilio Altaniga dismissed the case merely 20 days before the completion of summons submissions. We can only assume that maritime law admonishes all sense of critical thinking. Why would someone go through so much trouble to prove a point or innocence, and why would the courts try so hard to suppress the truth? Are they making easy money, while leading the respondent to the next greased spoke? It would seem the Florida judicial system is taking advantage of the Sestuiq trust. Lady Justice wears a blindfold, for a reason that does not mean that she reads Braille. We are anonymous. We are legion. We do not forgive. We do not forget. Expect us. End transmission.